Welcome back to Krishna's Law Reels. Today we'll be discussing about Article 22 and Article 23. Article 22 talks about protection against arrest and detention, whereas Article 23 talks about prohibition of traffic in human beings and forced labor. Article 22 gives protection against arrest and detention. So, Article 22 mainly grants protection to the person who have committed any offense and have been arrested or detained. There are two types of there are two types. Mainly one is punitive, another one is preventive. So here, it's not a case that if you have committed any offense, then only they'll arrest you. Even if you haven't committed any offense, still there are chances you may be arrested. So how come? Let's see. Punitive is something where you have committed a offense, then later on you have been arrested and you are under trial. Punitive detention is to punish a person for an offense committed by him after trial and conviction in a court. So, like at this time, you are being punished, like you've been punished because you have committed an offense. But it's not the case in preventive detention. Preventive detention is something where you haven't committed any offense and you're not even under trial, but still you are convicted. What do you mean by convicted? It is something like you are under police custody, you are in jail. Why you are in jail? You haven't did anything. It is because they are suspicious, they are under doubt that you might do something. It's something like precaution beforehand. Its purpose is not to punish a person. Here, when you have been arrested under preventive detention, it's not that compulsory you'll be punished. But it's for prevention, preventing you to do any future crime. Prevent him from committing an offense in your near future. In a sense, here you have been arrested, you haven't committed any crime, still they're getting you under the what you say detention because to prevent you. It's something like a precaution. You have took vaccine for COVID to prevent getting under like what infected with the COVID. Uh, Same things goes here. They are arresting you or they're detaining you to prevent you from doing any offense. Thus, prevention detention is only a precautionary measure based on an suspicion. So here they are only suspecting that you may do that. Like they don't have any proof. Like might be they have any proof, but still they are having a benefit or doubt on you that you might commit any crime. Article 22 has two parts. One is for ordinary law, another one is for preventive detention law. So, first part of Article 22, which is for ordinary law, it gives some rights to a person who is arrested or detained under ordinary law. So, when a person is arrested under ordinary law, he has right to know on which grounds or on what grounds he have been arrested. He has right to consult any legal practitioner, that is advocate. The person has right to be produced before magistrate within 24 hours. So here, why we say that within like it also includes the excludes the journey time. Actually, it's not. It doesn't include. It excludes the journey time. So here, when a person has been arrested, then he should be compulsorily produced in front of magistrate within 24 hours, and then magistrate agrees that okay, police can proceed and can keep him under what detention and can proceed with the trial, like court hearings and all. So the why do they produce before magistrate is to safeguard our right, because sometimes police people wantedly or falsely arrest you without any reason to just show their power. To like what to avoid these circumstances, they have inserted this that if within 24 hours uh, they produce you in front of magistrate and you are innocent, you are not guilty, then they may release you. right to be released after 24 hours unless the magistrate authorizes for future detention. Until and unless magistrate don't give acceptance or approval for further detention, they should, if they so case say I have been arrested and within 24 hours I was took to magistrate. Magistrate have denied my detention and said to release me. So within 24 hours I should be released. This is to safeguard our rights against, like what you say, arbitrary execution of police officers. Sometimes police officers wantedly do that, you know, right, how they behave. To avoid those kind of circumstances, these two rights have been inserted. These safeguards are not available to the enemy alien. It is only for Indian citizens, not for the foreign citizens uh, or detained under a preventive attention. And even for a these rights are not even applicable to for the person who have been arrested under preventive detention. These rights, okay, so above part 1 of article 22, those four rights what we have seen are not available to enemy alien, that is a person, foreign person outside India who comes and commits any crime. He is known as enemy alien. And even these rights are not given to person who is detained under the preventive law. Preventive detention law, you know, when a person doesn't commit any law, any crime, still he have been detained. That is known as preventive detention. The Supreme Court also ruled that the arrest and detention in first part of Article 22 do not cover. So again, they are saying what cases or what type of cases will not be covered under Article 22. One is arrest under the order of court of a court. You have been arrested under an order of court while a trial, ongoing trial. It is a civil arrest. Or arrest is because you haven't paid your tax, that is income tax. Deportation of an alien. In a sense, a person without, even after the expiry of his visa, is still in India. So at the time, they can't get these rights we have seen above. They may apply only to an act of these rights. Those four rights we have, which we have seen above, will be only applicable for criminal or quasi-criminal cases. And some other activities which are prejudicial to the public interest. So these above law, which we have seen, that is right to be informed the grounds, right to consult an advocate or legal practitioner, to be produced in front of magistrate within 24 hours, or to be released after 24 hours if magistrate didn't give any authority or approval for further detention. In this case, in these four cases, what is that? In civil arrest and income tax, failure to pay income tax, and of deportation of alien, you don't have those four rights. It is only available to the criminal or quasi-criminal cases. Whereas second part of Article 22 grants protection to person who have been arrested under preventive detention law. So this protection is available to both citizen as well as aliens. So here, in first part of Article 22, we saw that those four rights were only available to our citizens, not for the alien enemies, that is citizen or like per individual outside India. Here in part 2 of Article 22, this right is granted both to the Indian citizens as well as aliens. The detention of a person, under preventive detention, a person can't be detained or like arrested under like remain under custody for more than 3 months unless they have uh, like what, they were near advisory board and got a sufficient cause to extend the detention. What they mean is, if a person have been arrested and it have exceeded 3 months, then they need to go to advisory board and say what is the reason why they are exceeding the detention period, and they should give the sufficient cause. Then board board consisting of judges of high court, the advisory board consists of judges of high court, then they'll decide whether to extend it or not. The grounds of detention should be communicated to detentive. So who is detenue? Detenue is the person who have been detained, like arrested. So grounds of detention should be set to the person who have been arrested or is under. But however, the detenue, detenue means the person who have been arrested will not be set the grounds of detention if the case uh, is of security of our country, or else it is against the public interest. At that time, the reason or the grounds of arrest will not be disclosed. Here, the person will have an opportunity. The person who have been arrested will have opportunity to make a representation against his detention order, which will be considered by the advisory board. Article 22 gives some authorities to parliament. What kind of authorities article 22 have given to our parliament is to decide like on what circumstance and what kinds of cases a person can be arrested or detained for more than 3 months under a preventive detention law without obtaining opinion of an advisory board. So parliament has power to decide that if in what kind of circumstances, situations, or any kind of classes of cases when a person can be detained for more than 3 months even without considering opinion from an advisory board. They can decide, parliament can decide maximum period for which a person can be detained in any classes of uh, cases under preventive detention. Parliament has this right under Article 22. And Parliament can even decide the procedure to be followed by an advisory board while inquiry. Under a 44th Amendment, they thought to reduce the arrest period from 3 months to 2 months, but still it was not brought to effect. Right now in 2024, what they thought in 1978, they thought that we'll reduce it to 3 months to 2 months maximum period of detention, but now still we are following the same 3 months period. It have not not been bought in a sense, it never came in effect. Hence the original period of arrest is 3 months, which is still continuing. The Constitution have divided legislative power with regard to preventive detention between the Parliament and state legislative. The Constitution, like you know, right? Constitution gave our Parliament as well as state legislative powers on basis of like division. So here Parliament have right to make preventive detention on which cases. First, if it is reason of defense, or else any foreign affairs, or the case is related to the security of India. These things will be dealt by Parliament. Whereas Parliament as well as state legislature both can make concurrently, in a sense, overlappingly, can make laws of preventive detention for reason which have been connected with security of state in essence, any respective state. Here we are a state in essence, not India. Here state in essence, Telangana, Andhra Pradesh, like that, those states. If the case is related to maintenance of public order, or if the case is related to maintenance of supply services essential commodities. What do you mean by supply services essential commodities? In essence, this transport of we do like one state to other state essentials like onions, tomatoes, fruits, like that. uh, like we'll be sending, exporting, importing foreign or from inside state, we do that, right? Sending one essential, like say rice from south to north, wheat from north to south, like that. They can make preventive detentions on these all things, preventive detention laws. So parliament and state legislative concurrently, in a sense, both mutually can make. And here parliament can make on defense, foreign affairs, security of India. So the preventive, these are all the preventive detention laws made by Parliament. So Parliament made in 1969. We need not to remember these all things. It's just for like general knowledge kind of thing. You need not to worry. You just read it out once. It's enough, more than enough. One is Preventive Detention Act, which expired in 1950, which was made in 1950 and expired in 1969. Maintenance of Internal Security Act, that is MISA, which was made in 1971 and repealed, in essence, changed in 1978. Conservation of Foreign Exchange and Prevention of Smuggling Acts, that was made in 1974. National Security Act, that is NASA, made in 1980. Prevention of Black Marketing and Maintenance of Supplies and Essential Commodities, 1980. 1980, like these years are years when this act was formed, or this act was came in effect. So at the years which we are seeing, in these years, this particular act came in effect or it was formed. Terrorist Dispute Activities Prevention Act, that is TADA, 1985, which was being repealed. Repealed in a sense, few amendments were made in 1995. Here, Preventive Illicit Traffic, Narcotics and Physio Physiotropic Substance Act, that is 1988. Prevention of Terrorism Act, 2002. It have been repealed, that is amended in 2004. Unlawful Activities Prevention Act, that is UAPA, still in effect. 1968 it was originally made. It have been later on amended in 2004, 2008, 2012, and recently it was amended in 2019. It is unfortunate to know that no democratic country in like in whole world has made preventive detention as an integral part of our constitution, but still India have made it. It was effect like originally Britishers have imposed this act on us, but later on in our constitution we have adopted it. It is also it is unknown in USA. It was resorted in Britain only during the First and Second World War time. So it was unknown to USA citizens and even USA. In Britain only during the First and Second World War they have implemented it. In India, preventive detention existed even during the British rule. For example, Bengal State Prisoners Regulation Act 1918 and Defence of India Act 1939 provided for. Okay, so here they are saying while British rule, these two acts were like preventive detention. They were focusing on preventive detention. So we are done with Article 22, and Article 22 is all about arrest of a person. What is rights of that particular person? We have divided it into two things. That is, person who have been arrested because he have actually committed a crime. Other one is the person who have not committed the crime but still he is under detention, that is arrest. So we have seen what are rights given to them. Article 22 part 1 talks about the person who have been arrested under ordinary law. That means he have committed an offense and then he have been arrested, so there are 4 rights given to him. Hopefully you remember what are those rights. And again, Article 22 part 2 talks about rights of a person who have been detained under Preventive Detention Act. Later on, we have seen these preventive detention laws made by Parliament. Now we are coming to Article 23, which talks about prohibition of traffic in human beings and forced labor. What do you mean by traffic in human beings? Trafficking in something like selling and buying of human beings, like prostitutions, something like that. And what do you mean by forced labor? Forced labor is something where you are forced to work without any pay or remuneration. In a sense, they'll not pay you and they'll make you work without your will. Article 23 is prohibiting trafficking in human beings. Begar, it's not beggar, it's begar. Begar, in a sense, forced labor or bounded labor. Other similar forms of forced labor. So any contravention of this provision, that is prohibition and trafficking human beings and forced labor, shall be an offence punishable with in accordance with the law. The right is available both to the citizens and to the non-citizens. Here, Indian citizens as well as foreigners have this right. It protects the individual not only against the state but also against a private person. Because we have seen in Article 19, it was only protected against state, but here it is also been protected against a private person, because state doesn't does mostly state doesn't does this. No government person will hold you. No judge will say you should work in my home without any pay. So it's mostly done by private person. So this rights are in against private individuals as well as state. So the expression traffic in human beings, what does traffic in human beings include? Is selling and buying of men, women, children like goods. Uh, and then immoral traffic in human like women and children, that includes prostitution. You know, right? They do kidnap girls from like villages and they sell them in Dubai, Saudi, Malaysia, Bangkok, like that. Immoral trafficking, buying in like selling and buying in women. They even do sell men's like their organs, kidneys, and all. They do sell children for to let them beg on streets, something like that. Devadasis have been also banned, and slavery. Hopefully, you know what is Devadasi. In olden times, they used to capture them on the name like God. They are what they are belongings of God. Devadasis are like form of God who are only belong to God, and they'll only be in temple premises. They'll not go back to their home, something like that. And they used to be exploited by the priest, that is temple priest, pujari, or something like that. And even slaveries have been prohibited. To punish these acts, the Parliament has made the Immoral Traffic Prevention Act 1956. So this act was made to punish all these kinds of offences, originally known as Suppression of Immoral Traffic in Women and Girls Act 1956. So this Immoral Traffic Prevention Act originally was known as Suppression of Immoral Traffic and Traffic in Women Girls Act. The term begar, it's not beggar, it's begar, means compulsory work without remuneration. You should work, but you'll not get remuneration. It was peculiar Indian system under which the local zamindar used to force their tenants to render services without any payments. In olden days, it used to happen. In addition to Begar, Article 23 prohibits other similar forms of forced labor like bonded labor. You know, bonded labor is something like uh, in this, even in these days it does happen. They'll get a girl, like small girl or a boy from village, and they'll just give a lump sum money of 7,000, 8,000 to their parents, and they'll keep that person in their house, and they'll give them once of meal, only one time meal in a day, and they'll make them work whole day. So it's something like bounded labor. They'll stay in their home, they'll work on, like they'll only get food and stay place, that is under a roof, they'll sleep somewhere. So that is known as bounded labor. The term forced labor means compelling a person to work against his will. The word force includes not only physical or legal force but also force arising from the compulsion of economic circumstances. That is working less than a minimum wage, which I have said you. Same in the bonded labor, they get them from like mere 10,000, 5,000, and once in a year they'll be sending money to their parents. And that person, what about that person staying in home? They'll use them as machines. So it is, here we are saying force is not physical, not legal, but also economical. That can be less minimum wages also. In this regard, the Bonded Labor System Abolishment Act 1976 came in effect. So, to prohibit that, this act came in effect. The Minimum Wages Act came in effect. The Contract Labor Act 1970 came in effect. The Equal Remuneration Act 1976 were made. Article 23. So here, these all laws were made to prohibit forced labor, bounded labor, and begars. Here, Article 23 also provides an exception to this provision. What is exception to this provision is that state, that is government, can compel any citizen in case of military services or social services. If there is any emergency or like war where military persons are short, not short in a sense, short of number. So at that time, they can ask you to serve in military, or even they can ask you to do social service. Like in, say, COVID came in a large extent that there are no more medical practitioners. Like they are, but they are very less in number. At that time, government can ask every person from house, one person from house, to serve as a volunteer for frontline worker in health sector, because they are it is important, even in war, if the military persons are like comparatively low, then they'll ask citizens to help out, and it is compulsory, and state will not even pay for that purpose. It is not bound to pay. It means if they can pay if they want, but they are not bound to pay. However, in imposing such services, state is not permitted to make any discrimination on grounds of religion, race, caste, and even while imposing it, they'll not particularly select from that particular region, or they're not particularly not select from that particular religion. In a sense, even here they'll not do any discrimination on basis of on basis of religion, race, caste, or class. If you know any landmark cases regarding Article 22 or under Article 23, you may drop it in comment box. There are huge discounts going on in Mega Mock Test Series for TS and AP LAWCET 2024. Join now. You can just ping in WhatsApp or an Instagram. Link is in description box.